1. Introduction. 1. The effective prosecution of crime is instrumental to any state that has the rule of law underpinning its social contract, it being a fundamental value which undergirds our Constitution. Duly enforced, it could ensure that every individual, regardless of social or political standing, is treated equally. 2. The Constitution provides for a single prosecuting authority, the National Prosecuting Authority, NPA, and the only institution vested with the power and responsibility to institute charges and prosecute crime on behalf of the state. The Constitution makes it imperative that the NPA performs that critical role and function independently without fear, favor, or prejudice. Anything less would weaken the rule of law and stymie the nation's constitutional aspirations. 3. To fortify the NPA in fulfilling its constitutional mandate and insulating it from undue pressure and influence, the Constitution makes provision for enabling legislation like the National Prosecuting Authority Act 32 of 1998, the NPA Act, the main instrument in terms of which it executes its constitutional mandate. 4. Moreover, the NPA has over the years created and adopted a prosecuting policy, directives, and a code of conduct, the code, guiding its members as they execute their mandate and safeguard the independence of the institution. It is thus, as an example, in terms of the NPA Act, that only the President may, in terms of Section 12(6), provisionally suspend a sitting National Director of Public Prosecutions, a Special Director of Public Prosecutions, and DNDPPs. 1.1. Establishment of the Enquiry. 5. Advocate Nkobo Jiba, one of 4 DNDPPs, and Advocate Lawrence Sithambiso Mrwebi, the SDDP, who heads the SCCU, are both senior officials within the NPA. They had been provisionally suspended by the President on the 26th of October 2018 in terms of Section 12(6) of the NPA Act, following serious criticisms made against them in the courts during the course of litigation and in other fora. The inquiry was, as a result, established to look into the fitness and propriety of both Jiba and Mrwebi to hold office. On the 26th of October 2018, the President provisionally suspended Jiba and Mrwebi from their respective positions pending the completion of this inquiry. Inferred from the inquiry's terms of reference, the action was in all likelihood prompted by particular criticisms and serious allegations leveled against both of them in various fora, including courts of law, which raised critical questions regarding their fitness and propriety to hold office. The inquiry and this report are but intermediate steps in the process triggered by the President's suspension of the 2 officials under Section 12(6) of the NPA Act. Once this report is submitted, the President is required to make a decision regarding the future of both ADVs Jiba and Mrwebi in their respective positions within the NPA. Moreover, the decision must be made within a time limit of 6 months from the date of suspension of the officials, a prescription read in recently by the Constitutional Court, which had found aspects of Section 12(6) constitutionally wanting. This aspect is covered in greater detail in the concluding remarks of this report. The tour establishing this inquiry were published on the 9th of November 2018, with the President designating me as chairperson, assisted by Kagoso Maroka SC and Denju Valakazi. Together, we comprise the panel, led by N. Bawa SC. The evidence team included N. Sikakane and Raja Budlender, and Z. Gomid on the instruction of the state attorney. Jiba was represented by N. Arens, SC, T. Masuku, SC, and S. Fergus, as instructed by Mayavu, Inc. Mrwebi was represented by M. Rip, SC, and R. Ramawel, SC, instructed by Valakazi Tau, Inc. As soon as the inquiry was established, the evidence team actively engrossed themselves in the arduous task of evidence gathering, and the panel focused on putting in place the secretariat, the appropriate structure, the rules and format to follow, enabling it to execute its mandate with utmost efficiency. 1.2. The Terms of Reference. 11. The inquiry's tour were published on the 9th of November 2018 in Government Notice 699 of 2018 Government Gazette No. 40, 2029. According to the tour, the inquiry, upon completing its mandate, was required to submit a report containing all supporting documentation and findings to the President. 12. The scope of the tour was to look into the fitness and propriety of both Jiba and Mrwebi to hold office in their respective capacities. In relation to Jiba, and at the panel's discretion, the inquiry was to consider evidence arising from the cases referred to in the tour. 13. Due regard had to be had to all other relevant information, which included, but was not to be limited to, matters relating to Richard Menduli and Johan Wessel Buisen. 14. The inquiry was also required to consider the manner in which Jiba fulfilled her responsibilities as DNDPP, which included considering whether she complied with the prescripts of the Constitution, the National Prosecuting Authority Act, prosecuting policy and policy directives, and any other relevant laws. In her position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold the position and be a member of the prosecutorial service, she properly exercised her discretion in the institution, conducting and discontinuation of criminal proceedings. She duly respected court processes and proceedings before the courts. As a senior member of the National Prosecuting Authority, she exercised her powers and performed her duties and functions in accordance with prosecution policy and policy directives as determined under Section 21 of the National Prosecuting Authority Act. She acted without fear, favor, or prejudice. She displayed the requisite competence and capacity required to fulfill her duties, and whether she in any way brought the National Prosecuting Authority into disrepute by virtue of her actions or omissions. With regards to Mrwebi, and once again at the panel's discretion, the inquiry had to consider matters arising from the cases referred to in the tour as they relate directly or indirectly to his conduct. All other relevant information will also be considered, including but not limited to matters relating to Richard Menduli. In determining the manner in which Mrwebi fulfilled his responsibilities as SDPP, inquiry will consider whether he complied with the prescripts of the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold this position and be a member of the prosecutorial service. He properly exercised his discretion in the institution, conducting and discontinuation of criminal proceedings. 7. Findings and Recommendations. 1119. In view of the totality of evidence and in light of the evaluation in Part 6, we find that both Jiba and Mrwebi are not fit and proper to hold their respective offices. 1120. Central to the question of whether a person is fit and proper to practice as an advocate is whether that person is a person of complete honesty, reliability, and integrity. 271. This quality must be present throughout a person's practice as an advocate. 272. 1121. It is the function of the court to determine what is or is not improper conduct for an advocate. The court will take cognizance of the rules of conduct laid down by the Society of Advocates of a particular division and by the General Counsel of the Bar, GCB. 273. The court may prohibit conduct which, though not in itself immoral or fraudulent, may in its opinion be inconsistent with the proper conduct of a legal practitioner and calculated, if allowed, to lead to abuses in the future. 274. 1122. The court must take account of all the circumstances of the case with due regard to the demands of the proper administration of justice and the interests of the profession and the public. 275. 1123. The application involves a three-stage inquiry. 276. 1123.1. First, the court will decide whether the alleged offending conduct is established on a balance of probabilities. 1123.2. Only once this is established will the court decide whether, objectively, the advocate is a fit and proper person to continue practicing as such. 278. 1123.3. Finally, if the court concludes that the person is not fit and proper to practice as an advocate, then it has a discretion either to grant an order striking the person's name off the roll of advocates or to suspend the person from practice. 279. 1124. In fact, it has now been definitively established that the fit and proper test, as it applies to legal practitioners, is distinct from the fit and proper test which is applied to NPA officials under Section 9 of the NPA Act. While there is a direct relationship, the standards which are applied are idiosyncratic. For example, it is possible for a senior NPA official who is found not to be fit and proper under the NPA Act to nevertheless remain fit and proper as a legal practitioner. The converse is of course not possible in that a legal practitioner who has struck off their respective role will, by operation of law, cease to be fit and proper under the NPA Act. 280. 1125. In Jiba v. General Counsel of the Bar, Mrwebi v. General Counsel of the BAR 281, the SCA overturned the High Court's ruling that Jiba and Mrwebi were unfit to practice as advocates. 1126. The court, in doing so, distinguished between the fitness to practice as an advocate and fitness to hold public office. The court held that perhaps one may infer some form of incompetence with regard to her duties, which may be a ground to remove her from being the DNDPP, but not sufficient, enough to be removed from the role of advocates. Jiba, 1127, and considering whether in her capacity as Deputy National Director of Public Prosecutions, Acting National Director of Public Prosecutions, she had complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in her position as a senior leader in the National Prosecuting Authority and is fit and proper to hold this position and be a member of the prosecutorial service. 1127.1. The evidence shows that she had not been frank when engaging under oath with the court in full HC. Further evidence led before the inquiry showed that she had not been frank in her affidavit before the courts in the GCBHC and GCBSCA matters either, making general propositions regarding the functioning of the NPA, knowing full well that that process had not been followed in the specific matters which she was called upon to account for. Furthermore, failing to explain the exact process that had been followed in the Fool and Buison prosecutions. Her approach to the litigation was misleading, and in following that approach, she compromised her integrity and consequently cannot be entrusted with the responsibilities of the office that she holds. In addition, and as will be canvassed in the findings below, her conduct in multiple instances indicates a lack of conscientiousness. Her actions do not accord with the requirements set out under Section 9(1) of the NPA Act 1127.2. With regards to the Buison prosecution, the evidence establishes that she allowed and in fact enabled the independence of the NPA to be compromised. 1127.3. Furthermore, in the Buison matter, despite initiating the prosecution, she did not consult with the DPP whose approval was required, and when a dispute ensued between Washwa and Chalk, she refused to get involved and assist in resolving the issue. This reflects a lack of leadership. 1127.4. As an official in the public service, her actions in the course of her dealings with the courts, as specifically explained by Murphy J. in the Fool HC judgment, have undermined the principles espoused in Section 195 of the Constitution with regards to maintaining a high standard of professional ethics, accountability, and transparency. This has had the further effect of undermining the injunction in Section 165(4) of the Constitution to assist the courts to ensure their effectiveness. 1128. With regard to whether she properly exercised her discretion in relation to instituting and conducting criminal proceedings on behalf of the state, carrying out any necessary functions incidental to instituting and conducting such criminal proceedings and discontinuing criminal proceedings. 1128.1. Her failure to consider the extensive memorandum presented to her when charges against N. Maduli were withdrawn as an acting NDPP function in the discontinuation of criminal proceedings demonstrated a failure to properly exercise her discretion. The GCBSCA observed that she was not bound to follow the advice contained in the memorandum and that no misconduct could be established on that basis. This cannot be disputed. As far as properly exercising her discretion is concerned, however, as the acting NDPP, she was required to have a rational explanation as to why she opted not to consider the memorandum at all. 1128.2. The procedure followed in authorizing the prosecution against Buison, considering that she had herself initiated the prosecution process, was found to have been irrational and was set aside. In her capacity as acting NDPP, she failed to properly exercise her discretion in authorizing the proceedings. We make this finding without any suggestion as to the guilt or innocence of Boysen. 1129. Whether she duly respected court processes and proceedings before the courts, as required by applicable prescripts, and as a senior member of the National Prosecuting Authority. 1129.1. In her capacity as acting NDPP, she failed to comply with court processes within the stipulated time frames and drew strong criticism for displaying a lack of candor in her submissions and for failing to take the court into her confidence. 1129.2. She has been labeled supine in several judgments for failing to act in instances where she had been expected to do so. 1129.3. We find that as a senior member of the NPA, Jiba has displayed irreverence to the courts and indifference to their processes, resulting in adverse comments being made about her. 1130. Whether she exercised her powers and performed her duties and functions in accordance with prosecution policy and policy directives as determined under Section 21 of the NPA 1130.1. The policy explains that prosecutors are given discretionary powers by the law in performing their functions, exercising their powers, and carrying out their duties. The discretion must, however, be exercised according to the law and within the spirit of the Constitution, with specific regard to the principles of accountability and transparency which undergird the constitutional ethos of all state institutions. Jiba's conduct is found wanting. She was not forthcoming with the courts and did not take them into her confidence. 1130.2. The policy obliges all its members to serve impartially and to exercise, carry out, and perform their powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. Compromising the independence of the NPA, we find that Jiba dishonored this obligation. 1130.3. The adverse remarks made against Jiba in the various decisions, including legal submissions which lacked a constitutional basis, which she made in her official capacity, which drew scathing criticisms from the court, together with her involvement in the series of decisions which were all set aside on review for irrationality, were unbecoming for any official, let alone an official of her seniority. We find that Jiba's conduct had the effect of seriously damaging public confidence in the NPA. 1131. With regard to whether she acted at all times without fear, favor, or prejudice. 1131.1. The visit by IPID to herself and Mosing, the pressure exerted on Mosing to review 6 dockets and make a decision within a day, and Jiba's reasons in her affidavits, the representations to the President and before this inquiry, indicate that 1131.1.1. She allowed pressure to influence the manner in which the NPA dealt with this matter. 1131.2. The inconsistencies in the reasons she gave for establishing a national prosecuting team indicates that she acted with favor and with prejudice to the NPA. 1132. In relation to whether she displayed the required competence and capacity required to fulfill her duties. 1132.1. Jiba failed to attend to review as requested the decision taken by Mrwebi to withdraw the charges against Mindluli. 1132.2. She failed to competently apply the prescripts of POCA, the NPA prosecution, policies and the law in the Buisan prosecution. 1132.3. Once she had initiated the process, she failed to manage the dispute between Lachwa, whose jurisdiction the matter fell, and Chalk on a critical procedural aspect relating to the indictment. 1132.4. Jiba also failed to competently and timelessly comply with court orders, time, frames, and directives as set by the courts. 1132.5. Having regard to the above, Jiba failed to display the required competence and capacity required to fulfill her duties. 1133. On the question of whether she in any way brought the national prosecuting authority into disrepute by any of her actions or omissions. 1133.1. The series of Jiba's decisions taken in her capacity as a NDPP, which were all set aside on review, the comments and criticisms leveled against her by the courts have brought the NPA into disrepute. 7.2. Mrwebi. 1134. Whether in fulfilling his responsibilities as Special Director of Public Prosecutions, he complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold this position and be a member of the Prosecutorial Service. 1134.1. The Constitution is the supreme law of the Republic, and conduct inconsistent with it is invalid. It calls on all organs of state to, among other things, assist and protect the courts through various means in order to safeguard their dignity, independence, accessibility, and effectiveness. The NPA is bound by this obligation as an organ of state. 1134.2. The courts have expressed their displeasure at the manner in which Mrwebi has discharged the duties of his office and conducted himself towards the courts. Mrwebi's conduct was openly at variance with what is expected of a person in his position. 1134.3. In taking the decision to withdraw the prosecution of MDLULI without consulting with Mijun Yathi, Mrwebi acted contrary to the provisions of the NPA Act. 1134.4. Mrwebi did not act with integrity as required under Section 9 of the NPA Act. This is evident in his attempt to justify his conduct, where he inadvertently referred to a judgment which directly established his dishonesty under oath. This was evident from his representations regarding Ledwaba. 1135. In considering whether he properly exercised his discretion in instituting and conducting criminal proceedings on behalf of the state, carrying out any necessary functions incidental to instituting and conducting such criminal proceedings, and discontinuing criminal proceedings. 1135.1. In light of the adverse findings by the courts about the manner in which Mrwebi exercised his discretion to discontinue the prosecution of Mandaluli, we are of the view that Mrwebi did not properly exercise his discretion. 1135.2. Mrwebi gave contradictory versions when seeking to explain what was meant by the phrase "in consultation with." Mrwebi showed himself to lack an understanding of the law and the legal process. 1135.3. Furthermore, Mrwebi's lack of appreciation regarding his behavior in keeping secret the representations from criminal suspects implicated in the investigation carried out by the NPA into alleged improprieties perpetrated by officials of crime, intelligence, and his admission that he took those representations into account without verifying the truthfulness of their contents confirms that his decision to withdraw the prosecution of Mrwebi was irrational and unlawful. 1135.4. Mrwebi therefore did not properly carry out his functions incidental to instituting and conducting such criminal proceedings and discontinuing criminal proceedings. 1136. Whether he duly respected court processes and proceedings before the courts as required by applicable prescripts and as a special director of public prosecutions in the National Prosecuting Authority. 1136.1. By filing court papers out of time without a proper explanation or application for condonation and showing disregard and indifference to directives issued by the Judge President in full H.C. Mrwebi showed that he did not consider it an obligatory and serious matter to obey court directives and to comply with court deadlines. His attitude shows that he did not respect court processes and proceedings as expected from a SD in relation to whether he exercised his powers and performed his duties and functions in accordance with prosecution policy and policy directives as determined under Section 21 of the NPA Act. 1137.1. Mrwebi's conduct in withdrawing the prosecution of Mrwebi when there was a prima facie case and his flawed reasoning for withdrawing that prosecution were inconsistent with the provisions of the prosecution policy directives. 1137.2. The policy directives require that extensive police investigations be shown to have been carried out before a prosecution is withdrawn on the ground that there is no reasonable prospect of a successful prosecution. As established by the evidence, Mrwebi cared little about the merits of the Mrwebi case or whether a successful prosecution was reasonably possible. He simply decided that the matter fell within the jurisdiction of the IG and that it should be withdrawn and given to the IG. 1138. Whether he acted at all times without fear, favor, or prejudice. 1138.1. The circumstances surrounding the withdrawal of the prosecution of Mrwebi show that the 1st of January 1138 he took office on the 1st of November 2011. Proclamation indicates that the appointment was with effect from the 25th of November 2011. Received representations on the 17th of November 2011, immediately called for the docket and memoranda, and took a decision on the 4th or the 5th of December 2011, without reference to his colleagues and police, and without consultation with Min Yathi. 1138.2. It is therefore evident that he failed to act without favor and to the prejudice of the NPA in determining whether he displayed the required competence and capacity required to fulfill his duties. 1139.1. His lack of understanding of the law and legal processes surrounding the Mrwebi prosecution show that he did not display the required competence and capacity required to fulfill his duties. Whether he in any way brought the National Prosecuting Authority into disrepute by any of his actions or omissions. 1140.1. Mrwebi's decisions taken in his capacity as Special Director of Public Prosecutions, which was set aside on review, the comments and criticisms leveled against him by the courts have brought the NPA into disrepute. 1140.2. The lie he told under oath in the Ledwaba matter, which he further perpetuated. Before this inquiry, all point to Mrwebi bringing the NPA into disrepute. 7.3. Recommendations. 1141. Jiba and Mrwebi have been involved in litigation in both their personal and official capacities over the years. They have, however, failed to introspect and reflect on the issues which have beset the NPA with their involvement as reflected in this report. 1142. In the result, we recommend that 1142.1. The President remove Mokgoro Jiba from office as DNDPP, and 1142.2. The President remove Lawrence Sithabiso Mrwebi from office as SDPP,